sounds because I hear some sounds in the background. All right, hello everyone, and welcome back to another day of streaming of the Alec Baldwin trial as it gets started on day 2 with the continuation of the state's case. And we're here for it. We're all excited to join you.
Hopefully it's more entertaining than yesterday. At least when I popped in. Maybe great things happened when I couldn't be there. I will be on the road for a big chunk of this morning and then get back to a more stable location. And I'm deeply looking forward to that. I'm also looking forward to better witnesses, better questioning. Did any of you watch the follow-up last night from, I did catch DUI guys commentary, and I didn't know if you had any opinions, but he thought Spiro was a complete disaster. And I don't know if he was or not, but I would love to get your input on it. He thought the guy lacked charisma. He was not compelling, and he was claiming that the jury, and the reason why I wanted to follow him is he's in the courtroom. He said that the jury was eating out of Carrie Morrissey's hand, that her little, preschool sessions actually went over really well with the jury. So I was kind of shocked to hear that. But he said that they were like, ooh, really? All ears, completely captivated every time she did that. So I was shocked because he was talking about she was one of the best prosecutors he has seen in a long time. And she's got on our last nerve. So I thought that was kind of, it's like, eye of the beholder or maybe the location. Your thoughts?
I think two things can be true. I think she can be abundantly annoying and also be abundantly correct. And I think that's where she was with the line of questioning she had yesterday. Lots of people, I agree with the DUI guy that people, when we're watching it, it appears to be that she's talking down to them. When they are watching it, it could appear as though she's breaking it down for them. So it's not as condescending when they're hearing it through their ears in person. It just comes off as, oh, so it turns out there are other things in CAD and the defense was making a big to-do about nothing. Oh, yeah, there is no implication that he is or isn't guilty, and it's obvious that the prosecutors weren't trying to do that. So I could see where the DUI guy is coming from with that. From our angle, it could also be very, very true that she comes off as very condescending and grating. So I think both things can be true.
I spent 2.5 hours yesterday recapping last night on my regular podcast, and I actually re-listened to Spiro, whatever, his opening statement, and assessing just what a cluster fart it was. When I was listening to it again, it was so chaotic, and I think Andrea.
Oh, I'm so glad you agree with me because I felt like I was in the minority yesterday.
No, I said I didn't like it, but after I watched it again, I even called it a foul on the thumbnail because I remember it not being good. But when I was watching it, it was like he would literally go from one point and say, "This is what the main thing is I want you to remember," and it would be like a stupid point. And then 10 minutes later, he would bring up a completely different point and say, and this is the one thing you should walk out with. Like he did that like 3 or 4 different points. None of them were really good. They were all like one really, really bad point. It's like one of the main points that he was pounding home was that at the time of the incident, everyone was reporting as an accident. This is the most important thing you should remember. At the time of the incident, everyone was calling it an accident. And I was just like, and then 10 minutes later, he's going on about how it's really important. It was really important that you all remember that nobody here that he didn't put the bullet in the gun. He didn't put the ball in the gun, and that's the most important thing. And the next thing, and that's what's really important. You need to remember that's the most important thing, because if you don't remember that, in that case, you don't realize that's what this whole case is about. They never found the bullet because they weren't looking for the bullet, because he's the shiny object. He's the shiny object. That's what you really need to focus on. He's the shiny. It's like, I don't know what the hell I'm supposed to be focusing on here. None of these are great points. Instead, you should. Not once did he say Alec Baldwin felt badly about the death. he was pointing the finger saying it's the armorer's fault, it's Gutierrez's fault, it's the producer's fault, it's the police coming after him, and he painted him as being a victim, which is the worst way to paint a celebrity who's notorious for being a narcissist and likely to be hated and resented. That, hey, you're a narcissist who's claiming that he was so good, he's not going to insult anyone because then he's going to come across like a snobby actor. You're portraying him as a snobby actor. Everything he was doing, I was just like, he had a year, 6 months at least, to prepare for this. This is the one thing that every litigator can control, and you can set the framing and set it up.
Yeah.
During a trial, things come up. You don't know what's going to happen. Like things come. You have to fly the seat of pants. This is the one thing that I can set my framing here from how our theme of the case, and his theme was chaos, and that's why I think it's terrible. Go ahead. I'm sorry.
I feel like the problem here isn't a lack of charisma. I think he's got quite a lot of energy and the ability to connect. I think the problem is really, like you're saying, Joe, his lack of targeted messaging. It's just all over the place. It reminds me, I'm always reminded in a lot of these trial settings, I always think of that thing that Scott Adams says about the cognitive dissonance tell, when you have like 100 billion reasons for something instead of a simple explanation, a simple reason for something. It's a tell that you are reaching, that you are trying to reconcile something that you inherently know is incorrect. And that's the feel I got from his opening statement, that exactly like you're saying, it's because the armorer messed up, it's because the ADA messed up, it's because the law enforcement didn't investigate correctly, it's because there should never be any live ammunition on set, it's because the cinematographer told him to do it. Like, there's just reason after reason after reason. And I think the point that you're making there is that it just makes it very difficult to be able to connect with any one of those. It sounds like we're just starting from the position that Alec Baldwin must be not guilty, and whatever reason you need to come to that conclusion, I'll serve one up for you. If this one doesn't work, how about you try that one?
Yes.
And so, yeah, I think the risk is that it just comes across as insincere and perhaps a bit uncommitted. I didn't like his phrasing in a lot of places because I tend to think, just my impression already from this case is that he may be himself rather quite a lot like Alec Baldwin. He may kind of think along a lot of the same lines as Alec Baldwin. It's not uncommon. It's a lot of the ways that lawyer client relationships form is because you have similarities. You can relate to each other, talk to each other in your same language. And so there were just so many ways that he had of expressing things that I felt came across as quite tone deaf. The whole, this is an actor, this is different. This is about make-believe. It just, a lot of that stuff, I think, could have been, it's important points for him to make, but you just have to be so careful with your phrasing so that it doesn't sound like you're saying, ladies and gentlemen of the jury, this guy, he's special. He's not like everyone else. And they're just, I feel like there was some vetting of that particular argument that probably should have happened to make it, just make sure that you are landing that the way you want to.
Yeah, market test it, because what he should have done, what I was thinking, the best way for him to handle it, because the facts here are difficult for any attorney to handle. They're very difficult because at the end of the day, he's the guy who pulled the trigger. So that makes it very difficult. He didn't check the gun. He did point it at her. There's all these bad facts that he has to overcome. And that's why I think his theme, the healthiest theme for him would have been that this was a terrible accident. He feels awful about it. He has not a day of his life that hasn't gone by that he hasn't felt some level of grief over the fact that Hannah is no longer here and the terrible pain he feels for her family. And at the end of the day, this is what the culture is there, and that's why it's an accident. If you might look at him like he's some sort of star. I would have humanized him and say, you look at him like he's some star because you might have seen him in some movies or something like that. He's a man who's fallible, makes mistakes, just like me, just like you. We're all fallible. And this was a terrible, terrible accident, which had the worst possible result. But at the end of the day, it's an accident. And accidents, unfortunately, the same way I make mistakes and accidents happen and you make mistakes, he made a terrible mistake. But you need the most important thing for you to remember, the actual really most important thing for you to remember is that being part of an accident is not a crime. It's only if someone is reckless, if someone is really irresponsible. And he was not being irresponsible. If we consider the fact of the culture that he's in here, nobody in his culture thought that he was being irresponsible in the way he acted in any way, shape, or form. And since he wasn't being irresponsible and wasn't being reckless, while he's going to have to live with this accident forever, as many of us have to live with accidents that are irreparable, so too, those accidents are not something which become criminal. They're just accidents that are an unfortunate part of life, and this terrible tragedy is that accident. Short, whatever, and just focus on the fact that draw this line, because everyone knows it's an accident, draw this line. That it's accident, without any of that irresponsibility or lack of accountability. Show the accountability, show that he's responsible and that he's not a criminal because of recklessness. That's how I would have just pounded it.
I think what you're talking about is the importance of story, and as you said, the importance of framing. It's like you want a story, and what Karen Reed's defense did, for example, like Karen Reed was framed. And then you had, the 5 sentences before they got to ladies and gentlemen of the jury, which echoed, emphasized, and built on that theme. So you start just really simple. Karen Reed was framed. You have 5 sentences in support of it. And then you get to, ladies and gentlemen of the jury, and then you get to laying it out. But the idea is that you have a story that you're going to tell. The principal problem for the defense in its opening was not only did they have multiple different stories, but they were interlaced in a really weird way that made it very difficult to figure out what they were going to talk about at any given time. There was a problem with flow, right? Because what you really want is what you call in speechcraft is signposting, and this can be done in a subtle way. You don't have to do it explicitly. Like the explicit version is, I'm now talking about point 1, da 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 da. Now to talk about point 2, da 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 da. Right? So that's like a really explicit way. A more implicit way is you have, the ending of one point sort of roll into the next point, but it telegraphs where you're going to go so that the audience isn't surprised and they know where you're going to be. The problem I had with the defense's opening is they weren't doing that. They were talking about one thing, and then at least seemingly to my ear, without any particular signposting, without any particular indication, they just jumped into the next thing, and it was interlaced in a way that made it very difficult to tell a story. It was chaotic and disconnected, and they didn't have a consistent theme. And I think, Joe, your idea is essentially the idea that I think is correct and the better way to tell the story. But either way, you need a more coherent narrative.
I will say this. At first, I disagreed with you all. I was like, no, I like this guy. But then I happened to watch his opening yesterday again because I was watching some streams to see what other people said about it. But then I just watched it, and I think everything everyone's saying is 100% the way I felt coming out of it. I think Joe is saying what he was trying to say, but he said it in such a machine gun way to just throw so many different. It can't be his fault because of this, 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 and on top of this, because of this, but never humanized the man. He actually made him feel to me more like a comic book villain, like, hey, this guy did it. And I was like, oh my God, he's representing Lex Luthor here. But at the end of
not the vibe you're going for.
But I will say, when I gave my first opening argument, it was an opening statement. I was nervous as crap, and you go in with a plan, and then next thing you know, what comes out of my mouth wasn't what I wanted to come out of my mouth. You know what I'm saying? Because it's something that's you have a plan, and I'm assuming he had a plan, but that opening statement, to me personally, it didn't. He had so much more to work with. And I'm assuming, like Andrea said earlier, that that statement was more for the client and not for the jury. So the client says, this person's fault, is that person's fault, is this person's fault. But forget that Alec doesn't matter. It's the client is paying, but the jury you got to convince. So I'm hoping that in this process, he'll clean it up. But what Kurt said, I think, is 100% correct in terms of flow. Because listening to it again, I realized that I was impugning my own thoughts onto, because, you know, I've been dealing with this case. So I was like, oh, okay, I know why he's saying that, so he's saying that. But then when I stopped and started looking at it from somebody who didn't know anything about this case, like a juror, I was like, I don't know what the hell this guy's talking about. So it's kind of like that. Your own knowledge kind of puts you in that place. And I'm thinking that's why DUI guy and the rest of them had said that, looking at what was going on, it seems like the jury wasn't feeling it because they were in that position where I don't know any of these people. And now, you know, Lex Luthor is telling me why he didn't try to kill Superman. You know, what's going on? So right now, I think the defense has a lot to make up for. But I think the thing that's saving Alec Baldwin now is the fact that the prosecutor's opening didn't blow him out of the park. It was kind of like, So right now, I think coming out of that, you're really at a tie. And these first two witnesses didn't hit home runs, but soon we'll get those witnesses that hopefully for the prosecution will hit those home runs.
Yeah. But it's interesting that DUI guy says that in the room that the school teacher affect was playing better, apparently, to the jury in the audience than it was playing to us. Which, you know, if that's the case, then fair enough. You know, that's the people you got to convince. You got to play to the room. So if it was working for that jury, then, you know, hey, great, keep doing it because it's working.
Generally pretty skeptical about the mind reading approach to the jury.
Fair.
I don't think that that's grounded in reality. The problem is that, okay, let's take it at face value. Let's say, yes, the jurors were more attentive to her. People can be more attentive because they're horrified and shocked. I mean, it's very difficult to read what people sitting silently in a box taking in what is happening in the courtroom into what's going on in their internal processes. So I would expect that as somebody who is local, she is going to have a better sense, a better read on the jury, a better perspective on what is going to resonate with them, given who they are and who their local culture is and so forth. And so that could be correct. It could be that for whatever reason, yeah, they like it. Maybe they like it in the context of it's her talking down to this other lawyer, these New York people that they really don't like. I mean, there's room for that interpretation certainly to be possible, I think. But I would be very, very hesitant to make any sort of claim about the effect anything in the courtroom is having on the jury, because you don't know.
And if you listen to any lawyer who's interviewed jurors after the fact, what they choose to focus on is often not what the lawyer thought was important or what they even talked about. I particularly liked, I forgot who it was who said
Tim Potter.
But they said, like, I mentioned this point to the jury, something like 30 times they said. And after the fact, I was interviewing the jury, and it's like, I really wish you had talked about this thing, which was the thing they talked about 30 times. So somehow it didn't get through. Or I remember another case where a lawyer was talking about a mistrial, and there's like, oh, you know, we were disputing the leather jacket because whatever it was, the leather jacket was really important to that particular jury. So in trial number 2, the lawyer spent more time talking about this leather jacket because it was important to jury number 1. And then when he interviewed jury number 2, they didn't care at all about the leather jacket. It was totally not a part of their discussion. So it's like, what can you do? The chaos of the moment, man.
One thing I will give credit to Carrie, though, for is her ability to speak slowly and clearly and emphasize certain points. I think the biggest failure to the prosecution is that they did not outline the standard very well for the jury. They did not clarify what the law was for the jury. That, I think, was a huge failure on the part of the state, because after I went back and looked at his police interview and I looked at the standard and I looked at how the trial went yesterday, I spent a lot of time doing that last night. I did not sleep very well. After looking over all of that, though, I'm now convinced myself that this man is innocent on the law and the evidence that will be presented here, because they're not allowed to introduce the element of him being a producer, and because they are limited and unable to show the videos of him running around, pointing the gun around, being a jerk off, creating the scenario in which he created the danger. I think there's going to be a serious problem being able to convict him, unless the jury, I mean, if the jury knew the law. But since the jury, I don't think, understands those elements as well, and it wasn't explained to them as well by Erlinda, I think we're going to have some problems.
Yeah, it's tough to do that in the opening because you're going to cross that line into argument, right? And so we saw Alex Spiro getting called out on that, those objections being sustained and rightfully being sustained. But I think you are right that there is an art to being able to do that. They hear the charge and at least the basic elements of the charge as part of their initial instructions from the court. It's just that the jury is getting such a volume of information right up front, and they haven't settled in yet to this process and really gotten a sense of what am I trying to pay attention to? What am I not trying to pay attention to? It's a little bit of a flooding of stuff. And so I agree with you that a really important part of the opening is to try to refine it down and give the jury some assurance that, look, this is actually very simple. It all sounds very complicated, but the case turns on this issue, or the case turns on this issue. And here is how the evidence is going to come out to show you that that issue will resolve in my favor. Right. Missed opportunity potentially.
By the way, side note, I was right. She did try to bring a baby into the courtroom. Apparently, she was prohibited from bringing the baby in, and the baby was very upset that the baby could not also escort her into the courtroom. So I was right. I called it. She was going to try it, and she did.
The baby was denied access to the public trial, man. The baby
How
should
dare
sue.
we?
Babies like trials, too. Got to start them young, baby. That's what I'm saying.
Yeah, well, that baby needs the opportunity to fully participate as a member of their local government.
That's right.
Well, baby is the new hero prop, I guess, for this trial.
That's. I mean, I'm embarrassed for them. Honestly, that's so transparent.
It's so obvious. And I knew she was going to, I think I called it as soon as they seated the jury and I found out what the distribution was men to women. I was like, oh, they're going to try this. And they did. They did.
She could always try wearing sackcloth, since the baby thing doesn't work.
Ashes, sackcloth. She's more emotional than Alec Baldwin is. She looks more sympathetic than Alec Baldwin does. And she's not even an actress. Here's the thing. If Alec Baldwin, like I said yesterday, if he keeps his poker face and he's able to maintain that throughout the trial, I think he's golden. But when you have his wife sitting behind him going, it's setting a standard for what the normal reaction ought to be, what you should expect. And so when you see Alec Baldwin sitting there stone cold, it gives this air of arrogance and bitterness. So I don't know. It's just interesting. The way in which we view this trial versus the way that maybe the jurors view the trial versus the way that other attorneys may be viewing the trial. I noticed that potentially Criminal Sean, he had posted a picture of Alec Baldwin leaning over and he was like, that's not a good look. But I'm like, yeah, but if you watch the actual opening arguments, he's looking at his attorney. He's looking at the podium. He can't see the podium unless he leans over. So it's just interesting. It's interesting to see perspectives and how shifting the framing really does alter everything you know about that particular subject.
Yeah, I do think it's an important skill as an attorney to have the epistemic humility to recognize you do not see this case the way that the jurors do. It's just inherent in the training that we get, the way that we learn to think and analyze stuff. It puts us in a little bit of a different mind frame than people who are approaching it from more of a standpoint of common sense and just trying to do right under the circumstances, which is what most lay people walking into a courtroom are going to think their responsibility is. We, the lawyers, get very caught up in the technicalities of the elements, the burdens, all of that type of stuff. And it's not that the jurors don't care about that, but it's just that to them, those are means to the end of what they're trying to accomplish, which is to do justice in the case. And we have no idea how they are going to ultimately work that out in their own minds about what that means and how it applies given what they see in this case.
And I actually learned that as a first-year law student when I was taking legal writing. And so at the end of legal writing class, we had to actually debate. Like, we would take a side and write a brief and do all that good stuff. And at the end of it, we had to present oral argument. And you're given one side of the case, and the other. And I was given the government side in that case, and my adversary was given the defendant's side. Sorry, just the opposite. But that's not relevant to the story. The point being that I walked in there, and I was just like, I don't even understand where the other side's coming from. I don't understand what the hell they have. And I'm sitting there waiting nervously before my classmate, and sitting across from me, who's going to be arguing against me. And out of the blue, he just looks up at me and goes, "Thank God I got the government side. I don't know what I was doing if I was sitting in your chair." And I was like, wow, that's how you look at it. Because when you're entrenching yourself for months in a certain angle position, trying to figure out what angles you have, that starts looking to you as if that's the way every person sees this. And and you have to learn to remove yourself from that mindset and just say, okay, if I wasn't married to this particular client, if emotionally, financially, and as far as developing a relationship with them, because you're working with them day after day and trying to find any way to parent them like a mother, carrying that case home for them, and they weren't my child, how would I look at this case? And it's a completely different perspective. And that, I think that's a reflection at the early stage. You actually care and you're invested, but you sort of need to learn to divorce yourself from that to be effective. So
one of my favorite exercises in law school was when I was doing moot court, doing a fake appeal. And you didn't know which side you were going to be on in any particular round. So you had to write briefs for both sides.
Wow, that's
so
cool.
you wrote brief both ways. And so you wind up in a position where you're trying to write a brief that can't be beaten and has to be beaten because you want both sides to be able to win. And that's a great, that's a fun exercise to be able to do.
Yeah, we didn't do that. I was on moot court. We didn't do it that way, but I think that's a great way of using moot court to really better help you harpen your individual skills and identify genuine weakness in your own argument. And thereby and try to compensate and really, frankly, what he was doing yesterday, his job, framing, that is essentially what every attorney who's litigating is engaged in, is framing the position, framing the arguments in the way that makes it most likely for your client to succeed. There's a famous story of an attorney whose name is slipping my mind, who took exact opposite positions before the Supreme Court, like 2 weeks apart. You remember the one? Which one is it?
No, not off the top of my head, but I've definitely heard it done.
And the bench even asked him, "Weren't you arguing the exact opposite thing 2 weeks ago?" And he's like, "Different client."
Yeah,
exactly. So
we had to switch. I remember in our IP moot court, we had to switch, and I screwed up so bad because I started arguing the opposite standard, like at the end of our competition in regionals. And I was fortunate enough that one of the panelists was like, "You were dead wrong, but I believed you for like the first 8 minutes." I was like, "Yes." But, like, he was like, it took two other panelists, licensed attorneys, to sit me down and be like, "No, she's wrong, and here's why." So congratulations for you on that, but you did get it wrong. So you lost points. But I mean, it does happen, and it's hard. It's hard to remember that, like, you're not tied to one position, and you can't ever be tied to one position. You have to always be looking at the opposite side and saying, how's the jury going to interpret this? But then you also can't plan out your entire argument trying to combat the defenses that you expect them to bring, right? So you have to kind of head them off at the pass, but choosing which issues and which topics to sort of head them off at the pass at is difficult to do. It's difficult to figure out, okay, well, what are they going to focus on in their oral argument? What is it that they're going to bring to the table? And what is it that I absolutely must head off right now, right? Where do I cut it off right now? Whatever argument they're going to bring to me. And we do this all the time, right? Everybody in chat, whenever you get in a fight with someone, you're like, I know you're going to say this, you know? And so you're already planning out what the opposition is going to say, but you really need to be careful not to make your entire argument battling the other side, but rather proving your case.
And
Looks like we're going to have whiteboard time. That's very exciting.
Yay, I love whiteboards.
And that is, Danny, one thing that the prosecution did that I think was very effective when they started off their opening argument with, or their opening statement with, this is playing make-believe with a real gun. I thought that was such a good point, because that's going to that heart of what the defense is saying. Well, this is all just pretend stuff. And since it's all pretend stuff, you know, we use different rules. We have these people that we rely on to make sure that we can safely pretend, but it's never supposed to be real. She just got straight to the throat and pointed out that, yeah, you might have been playing make-believe, but it has very real world consequences when you're dealing with real firearms. And so that was such a strong point for her to start off with. It was unfortunate, I think, to see that kind of get lost in the just blizzard of facts and names and things like that were kind of thrown out in the rest of her argument. Had she more effectively weaved that through her presentation, I think we would have had a lot stronger impression of the state's case here.
I 1000% agree with you. And, you know, we were talking about standards yesterday too. And I went back and I watched Baldwin's interview, the police interview right after the accident. And it was interesting because in the interview, he claims that he really trusted his armorer, that, you know, she did everything right for the first 2 weeks. We had no problem. She handed me a cold gun, which either meant it was full of dummies or there was no ammunition and there was only a cosmetic piece in the front. That's what I thought was in there. I trusted her. You know, and it's very convincing and it seems very, very genuine to me. So I am curious to see how this plays out. And that's why I say I wish that the prosecution would have hammered home the law and what the standard is rather than what we would like it to be. And well, what it is. And then when the defense came up, it would have been great to have heard an argument about what we wish it was, right? So here's what the actual legal standard is, and then have the defense come up and say, that's great, but here's the industry standard. Here's what's normal. Here's what's expected. There's no way that he could have violated the legal standard of criminality under the industry standard of behavior and the way in which he relied on the people who were there to keep them safe. What is that sound? That's not me.
No, I think that's from the courtroom.
That's Joe.
Oh.
I was trying to figure some stuff.
Yep, you need to figure that out. I'll mute your mic for the moment. Yeah, so anyways, I think this is going to be interesting as we see how it develops further on day 2 with the issues that are presented. And so far, you know, we haven't heard a whole lot here. We've heard from, you know, the first responders who came to the scene, and, you know, we saw tape relating to the injury as it was unfolding, and it was, you know, emotionally resonant, but it didn't really, and we did see a little bit of, you know, some of the initial statements of Baldwin and some of the initial statements of some of the crew with respect to what they thought was happening. So there was something there, but we'll see how it develops here further.
Yeah, I think there's always going to be a lull in a case that's got technical evidence in it, because you just have to get through that foundational stuff that is, it's tedious, it's boring, but it's just necessary. I always do kind of wonder, trying to put myself in the jury's shoes, because they don't know all this stuff. They don't know what we, the lawyers sitting here on the panel, are thinking to ourselves. Yes, okay, they have to establish the chain of custody. They have to establish the authenticity, that it's still in the same form as it was, et cetera, et cetera. And they're not allowed to get into personal things that are beyond their personal knowledge. So, for example, we had that evidence custodian testifying about all these suspected live rounds and the submission to the FBI and stuff like that. But she doesn't get to come out and tell us, here's what the FBI found, right? Because she didn't make that finding. The FBI made that finding. So they're going to have to come in and do that. We know that stuff sitting here as lawyers, but the jury doesn't know that. I always do wonder, do they hold that against the party? Are they holding that against the state, wondering why they're not hearing what they expect to hear at this point in time? I definitely hope not. But it's just a necessary technicality that they have to get through. And so hopefully they are most of the way through that. And now we can move on to a little bit more of the substantive stuff.
Looks like the jury's coming in, so it looks like we're about to get started here.
Just as a reminder for everybody, we are on the cross-examination of the woman who's in charge of collecting and maintaining the evidence. So she was
Marissa
collected
Poe.
all the
What was her
rounds.
name? What was
I
her name?
called her
Marissa.
Pat, so I don't remember.
There we go.
There we go.
Marissa
Marissa
Popel,
Popel.
crime scene tech. There you go.
Poe, right.
Yeah, I give nicknames to all my witnesses. So Marissa, she's the crime scene technician. She is the one who talks about all the ammunition that they discovered on set, that there were live rounds, allegedly, that were on the belt with the dummy rounds on the ammo belt that Alec Baldwin was handed by Halyna Gutierrez. There was loose ammunition everywhere. They had collected these 2 boxes, and within the boxes, she showed the one silver primer. What's interesting about that is that I think today we're going to get in a discussion about patina. That's my hope. I want to bring up the patina situation. So this should be a lot of fun. What was interesting too with the Halyna Gutierrez, if you don't mind me saying, is in Halyna Gutierrez, they showed that the primers could be different colors. The sound, we have no sound.
No, there is no sound. I was just double checking, but my
No,
sound
there's no-
volume is up all the way. So
Does anyone else have sound? Other stream?
No, that's what the way they do it. They mute it until they turn it on. That's what I noticed yesterday.
So
There's-
annoying.
yeah.
Also, to my
Miming
chat,
thing.
we are playing bingo, and I will mark the bingo slots that I see as we go along in chat, so that way I don't interrupt the panelists.
Yeah. See, look, when you finished off, and you were like, and that's why this should be really exciting, and you were like, and here we go, and go.
Yeah, I
and,
was.
and it's muted, and we hear nothing.
And here we go. This is going to be great, you guys. Are you ready? This is going to be the best witness testimony we've heard so far. Yeah.
Yes.
I'm excited. They have a whiteboard. That means he's more organized today. I think he's got a clue. I think maybe one of his co-counsel sat him down yesterday and said, look, bro, you've got to get some freaking bones in that skeleton. Like, you can't just, or bones in that body, skeleton in that body. You can't just start throwing out arguments and expect it to land with the jury. We need structure.
Hopefully he saw my recap.
Maybe he
We
did.
actually see. I mean, I'm saying it as a joke because I think it's pretty funny. But we actually have seen in other trials where counsel who are involved in the case end up watching various channels on YouTube.
There's
and
audio on a different channel for some reason, so AP doesn't seem to have audio for some reason. So I'll just bring up the.
Just go to Crime TV because they're the ones who are authorized by the court anyway.
Yeah.
Well, AP let me down. I apologize.
Wouldn't be the first time AP screwed up and let everybody down. So
people are not going to be picking up trash that you all can pick up. Okay, and that also means downstairs in the jury assembly room. So one more cup, one more water. Let's just have some manners on picking up after ourselves, okay?
We're literally
next
getting schooled on
jury?
decorum. It's funny.
That's a good thing
So-
for
yes,
Baldwin.
the jury
Is that okay?
or
do
the
you want-
lawyers?
They said it in the jury room.
Oh,
They're a bunch of slobs.
Hey, that's
The
great
jury
for
room,
Baldwin.
jury room isn't being clean.
yeah.
Just- are you
Lyle,
comfortable?
lol.
Oh, well, I don't pick up my cups. How was I expecting Baldwin to check his gun? Kidding.
That's right. That's right.
Sounded way
Love
more
it.
disparaging than I meant.
Use it in your argument, and see, yeah, that'll be good.
Do you guys have any idea do we have any idea like what kind of order the state's gonna go in?
200 watt, man.
Well, I'm really good that I panicked so hard with the audio. I saw the woman talking on the screen. I was like, "Oh, testifying must be happening. Let me go panic." Really glad I did that.
Me too, because now we know we have audio. So it was a preemptive panic. Good for us.
As Uncivil Law questions whether he's competent as a streamer continuously.
Dude, I do too with freaking YouTube. I don't want to drag that in. That's a side note.
It was nice seeing the spring loader prop knife. So that was another thing that bothered me. He kept referring to it as a prop gun, It's just a prop gun. Yeah, you know what? Prop guns, this is a prop gun. Okay? When you take a vape and you try holding it as a gun, that's a prop gun. When you're holding something that successfully ends up deleting someone, that's not a prop. That's just a gun. You can call it a prop what you want. Maybe it's being used as a prop. It's a gun. And it sounds so disingenuous that you're trying to and the reason I think it bothered me is because you're making it as if this is no big deal. It's just a prop gun. And that's part of the irresponsibility, is that you're treating this gun. That's part of the problem here as to why Halyna died, is because he's pretending it's just a prop and ignoring the lethality of it. And that's why I think that whole language of prop gun that he thinks is helping him is actually hurting him. It's part of understanding how people hear what you're saying and how they're interpreting it, which I think he seems, as a couple of you have said, tone deaf, just completely tone deaf.
And he doesn't do that in the
interview.
interview.
We saw a lot of pictures yesterday and heard about some search warrants that were conducted that you were present for. And I'd like to sort of divide what we do this morning into sort of two categories: the firearm and the ammunition. Does that make sense?
Yes.
Okay. As to the firearm, I think where you left off yesterday is ultimately that firearm was destroyed in the testing. Fair?
Not destroyed, but broken.
Yeah, the word broken, that I think I heard you use yesterday. It's fair to say that the firearm can't be put back in the original condition that it was in at the time of the incident. Is that fair?
I believe it could be put back together with replaced parts. But as far as, in my terms, destroyed meaning no longer in existence, it is not the case.
Right. No, of course. The gun and its broken parts still exist, right?
Yes.
But as being part of the investigation and entrusted with the evidence in this case, the gun will never be in exactly the same condition that it was in on October 21st. Fair?
Yes.
Then I want to talk to you now about the ammunition piece of this. And the investigation into the source of the lethal bullet in this case led you to executing a search warrant at Seth Kenney's prop house, right?
Yes.
And you knew that he had provided star-line brass silver ammunition to the set, correct?
Yes.
What you were investigating at that time was whether it was star-line brass silver and only dummies, or if it was star-line brass silver and he also had live ammunition at his prop house, correct?
Yes.
And you did know that Seth Kenney kept live ammunition at his prop house, correct?
I believe at that time we were looking for live ammunition, yes.
Right, but you were aware of whether you found the exact correct live ammunition that matched perfectly the live ammunition on the movie set. You did ultimately recover some live ammunition, and you had probable cause to get a search warrant, right?
Yes.
And did that concern you that in a prop house that's sending out ammunition for movie sets, that there was both live ammunition and dummy rounds?
Yes.
So I want to take a step back for a second. When you go out to collect evidence on a day like October 21st, 2021, you bring with you your Nikon camera, right?
Yes.
You have gloves with you, right?
Yes.
And in a perfect world, you're trying to get to the evidence and the state of the evidence as quickly as possible. Fair?
Yes.
And so you did respond to this scene, and the first item that you collected that ended up broken was the prop gun, right?
Yes.
And when you got there, you knew that someone had touched it without gloves on, right?
Yes.
You knew that when somebody collected it, they didn't take a photo, right?
Yes.
But you did take that into evidence, and that was sort of the first item in this case that you were collecting and entrusted to keep vouchered and maintained for the course of this investigation. Is that fair?
Yes.
And it was a critical piece of evidence. Isn't that true?
Yes.
And so as you continue after that moment into the scene, you're looking for additional evidence. Yeah?
Yes.
And physical evidence is critical evidence in an investigation, right?
Yes.
Because, witnesses and their memories can change. Witnesses can say one thing one day and another day, but physical evidence pretty much stays the same,
I'm
right?
just objecting to a compound question.
Physical evidence stays the same, right?
Yes.
And you logged all the evidence you collected in this case?
Yes.
And all the evidence collected by law enforcement in this case was ultimately logged by you?
Yes.
And by logging it, you also make it available for the defense so that we have visibility into what in fact you collected.
Yes.
And one way you figure out as you're going through a scene what evidence is relevant is you can talk to your fellow officers, right?
Yes.
You can talk to witnesses, right?
I do not. As part of I'm not an investigator, I'm a technician. So my concern is with the physical evidence. I don't do any of the interviews.
No, I know you don't do formal interviews, but in this case, you did talk to Seth Kennedy, right? You're not forbidden to speak to somebody who's at a scene.
No, I do believe we had some casual conversations, yes.
Well, but there are times where a witness could say in your presence, hey, that glove is very important. And they would say it to you and Corporal Hancock, and you would
I
know.
object to the hypothetical.
Overruled.
As I was saying, you and Corporal Hancock could be at a scene, and somebody could say, hey, that glove was used. And you, as a technician, would say, okay, that witness is pointing out that glove, that could be important. I'm going to note that, and once I confer with Corporal Hancock, potentially take that into custody, to take an inventory.
Yes, that's something that could happen, yes.
And the other thing that you do is, and you talked about this a little bit on your direct, which is you can learn information, decide what to forensically test. Fair?
Yes.
So in this case, for example, Mr. Baldwin's clothes had red on them, and you tested it for blood, right?
Yes.
And it turned out it was movie set blood, right?
Yes.
Meaning it wasn't actually blood.
Correct.
Okay. So as you continue through the scene, you get to the prop cart, and you find the shell casing. And I thought this was on just a moment ago.
All right, Joe, come on.
All right, I'm showing the super chat. This made me laugh. Thank you, 200 Watt Studio. I needed a giggle this morning. Thank you. Does he have bad allergies, or is he crying this morning? Did he eat breakfast?
Just in the way.
Is he going to draw out this grid for each and every fact he puts down and waste our time?
That you had a problem.
Why didn't he draw?
And I'm
it?
putting States Exhibit 29.
I'm just a minute, Mr. Spiro. I'm wondering if.
Oh.
you're trying to figure this out.
I'm really glad I'm not the only one with bad penmanship in our profession. Soothes my soul watching him write.
I always think my penmanship is really good, but then people can't read it, which is kind of weird for some reason. I think they're all biased against me, though. So I'm pretty sure.
That yellow tie is definitely something, man.
He
It is
seems
something.
he seems more in his element this morning so far. Like his
What
tone and demeanor seems much more seasoned than it did yesterday. Yesterday he seemed nervous coming out of the gate.
What he's doing from a technical standpoint, he's doing extremely well. This leading and pacing of the witness. It's just I don't know why we're talking about this. This isn't a
and I'm
Karen
showing
Reed
you
was framed
Exhibit 29.
defense. So what am I supposed to
In a moment,
learn
I'll
from a
show you
bad
Exhibit
investigation?
28.
I was asking that throughout.
The shell casing that you recovered in this case that housed the lethal projectile, correct?
Yes.
And in fact, you were able to then recover the actual bullet piece of the ammunition because you learned from Mr. Baldwin that it was at the hospital with Mr. Souza, right?
Yes.
And so you were then able to go to the hospital, and we heard from that officer, and collect the other piece of the ammunition, correct?
Yes.
And that's an example, right, of learning something from a witness and making a decision based on it, right?
Yes.
Okay. And as to the prop gun, because you learned from Mr. Baldwin that he just manipulated the hammer, you didn't test the trigger of the firearm, correct?
I'm sorry. You're asking if I myself tested the
Trigger, yeah.
I'm not qualified to do that, so it was not completed by myself.
Well, fair to say that because you learned that from Mr. Baldwin, it impacted the way that you evaluate the evidence.
I object to the form of question. Can we approach?
He does have much better control over the witness,
Yeah.
the argument.
Yeah.
Definitely taking a deep breath.
And I agree with what you're saying, Andrea, that he the nature of trying to make it as if he did the same thing yesterday. Trying to make it as if we don't know who the killer is. They haven't proven that who the shooter is kind of silly and a waste of time. On the other hand, if his objective here is to try and get his bearings back and get back into what he knows how to do better than what he did yesterday, I can understand it.
Briefly, yes.
Okay. And he informed you that he just manipulated the hammer and that impacted your future testing, correct?
I don't recall what he exactly stated on the scene.
Okay. Well, let me just approach you for a moment.
Counsel, I'll make a copy.
We'll provide you.
200 watt. You're just nailing it today.
We're also going to need, while they're looking for that, why don't we approach?
There's a lot of approaching.
That's what the judge wanted. And that was so
Yeah.
frustrating to see in the pretrial motions. They were like, oh, well, that's not how I've ever done it. And she's like, well, that's how we do it. And I'm like, yeah, but Morrissey never follows the rules. Morrissey always does speaking objections and starts talking over everybody. And she doesn't approach the bench immediately. So, it just destroys the cadence of the defense, and I just don't think it's fair, frankly. I got to take this call. I'll be right back.
I think it's interesting, with respect to how this is purportedly resonating, that Morrissey is purportedly resonating with the jury, while most of us found her grating. It could be some litigators will try and find people who seem like they're the same type of person as themselves, as an ideal juror, feeling like they're more likely to relate to each other. And it could be she's got a whole bunch of, everyone was calling her a Karen yesterday. It could be that she purposefully selected a whole bunch of Karens for the jury.
A bunch of snotty kindergarten teachers.
Yeah. It could be that that's what the jury is comprised of. There's 11 women and 5 men.
By the way, of course, we do appreciate everyone who super chats to the respective channels. We do appreciate it, and we'll make sure to try to bring up everyone's super chats on screen.
We try to bring them all up on screen, and the larger ones we're going to try and make sure we read if we can. Like the ones like $20 and up, we're going to try and make sure we read those out loud and address them.
Page 3, lines 9 through 11. and I'm showing the witness. Does this, and as you can see from up here, this is a lapel camera from 1021, a lapel recording from. Do you see this answer here?
Yes, I see it.
And so, does that refresh your recollection that Mr. Baldwin told you that he cocked the gun?
I don't recall that conversation.
Okay. But you don't dispute that it happened?
No, I don't dispute it. I just don't recall it.
So did but when you made the request,
Objection, let's approach.
Well, we're having a lot of objections here this morning, have a difficult time getting into the flow of things.
Yeah.
This witness has been on the stand for what, 20 minutes at this point, and we've got 3 questions out or something. Yeah, man.
I don't understand. I really don't. I don't understand this approach with this witness. He seems to be trying to go down the road of, you didn't try to verify the story that he gave you about the gun firing by itself. Isn't his beef with that with the FBI with the testing? I'm not following why we are going down this road with this witness. It's not clear to me. It seems to be this kind of knee-jerk defense reaction where if there's a witness on the stand that the prosecution has put on, you have to challenge that witness for some reason. Like you don't always.
Sometimes it's better just to let things go.
Yes. Yeah. This doesn't matter. This is all foundational. It doesn't hurt you.
He made the same mistake yesterday during his opening statement, where he was like, the police failed to secure that prop cart throughout their entire time that until the very next day. And it's like, and then he goes, and that's a really important thing for us to remember. And I'm like, and I'm sitting there and I said, for the life of me, I'm an attorney, I'm following this case, I cannot imagine why that's a really important thing. Why not follow up with like, because, but he never got to a because. He just left that out there. It's a really important thing for everyone to remember, that they didn't secure it. They didn't get a warrant for that prop truck for a week. Okay. So there were live rounds that were found. So what? We all know there were some live rounds mixed in there. That's just, that's elementary, Watson. So who cares if they were negligent in their subsequent police evidence gathering, because this was not some sort of investigation. This is not a Karen Reed type of situation. We're trying to figure out a whodunit and try and just get to the bottom of it. I think it's safe to say that trigger was pulled, and that then the pulling of that trigger is ultimately what led to her death. So it's pretty dumb. But maybe he's just trying to get his bearings. I don't know. I'll give him the benefit of the doubt. Why do people waste their time and money on cases that are open and shut? I mean, how much money in combined spent on this case? Alex is guilty 10 ways to Sunday. Yeah. So the answer to your question, Nirvana, is that there is the real issue here. The real question of fact is, was he sufficiently irresponsible that we call him reckless? And that's where I really think the defense should have hammered home, and they failed to. And he really failed on that yesterday, and focusing everywhere else, blaming other people. But the reason is because this definitely is an accident. He's responsible for an accident, but he's not criminally responsible unless the state can prove he was irresponsibly reckless. And that's what led to the accident. So will a jury consider this irresponsibly reckless? And that's why there's really a trial going on here, because accidents we're not criminally liable for.
Well, and Alec Baldwin is certainly not going to roll over and just accept, okay, I'll be a felon and have a prison sentence.
Or on the cart?
On the cart.
And another question is, do you know if Mr. Baldwin's fingerprints or DNA were on the trigger of the firearm?
I do not know those results off the top of my head.
Is there a better
There's a
witness
dispute
that
as
may
to whether
come
he
in
pulled
to
the
tell jury
trigger.
that?
I
Yes.
guess.
Okay. And
All right.
you were interacting as we were left off with Mr. Baldwin at the scene and spoke to him, correct?
Yes.
Okay. And after speaking to him, did you in fact test the hammer of the? Did you in fact request to test the hammer of the firearm for prints and DNA?
Same objection. That doesn't lay the foundation. It has to go to why she did what she did.
It's the first question, and then I'll ask why she did it.
Overruled.
Did you, after speaking to Mr. Baldwin, did you then test the hammer of the gun for DNA or fingerprints, or request that it be done?
The request that was made was after a conversation with the lab, which essentially was asking them what assistance they could provide. I believe the request was made for latents and DNA. I don't recall the specifics of what on the item they were going to specifically test. I don't know their requirements or standards when they receive a firearm. Most labs would do the testing on the entirety of the gun, but they might break it down further and do just the trigger, just the hammer, just the rough areas. I'm not certain. That's a question for their lab.
Right, but I'm just asking you, Investigator Papa, when you made the request, did you specify, given what we've learned now, we really want you to check the hammer specifically? Did you make that request?
I don't recall specifically requesting that.
Maybe the reason he's going down this whole thing is that he's thinking they grabbed the wrong gun. And the gun that Alec shot with
when you got
was much more defective and went off by itself. Maybe that's his theory. But he's never spelled that out yet.
You could not tell from looking at it whether or not anybody had altered or moved any of the evidence, correct?
Correct.
And if somebody did, that would be a pretty serious problem in a case like this, wouldn't it?
It would be a problem in any case.
I think his theory is
Did
that
you ever interview or review any
they
interviews
can't
of
check the
Sarah
gun.
Zachary?
There's no way to verify any of this.
But one thing that you
that's
did
where he's
know at
going.
this time for certain is that you were looking for Starline brass silver 45 ammunition, correct?
At that time, no, we did not know that that's what we were looking for.
When did you learn that?
That was learned later on once realizing that all of our suspected live rounds were Starline brass with a silver primer.
So all of the live rounds at the movie set were Starline brass, nickel primer, live, right?
Yes.
And this idea came up early in the investigation that what if somebody sabotaged the set and put those live rounds there? Do you recall that?
Yes.
And that was quickly dismissed in this case as not something that law enforcement thought to be realistic. Fair?
Yes.
But you also needed to investigate whether somebody from outside of the Rust set was responsible for injecting these live ammunition into the Rust set. Fair?
Yes.
And so you continue to investigate that as this case proceeds, and you executed search warrants, correct?
Not myself personally investigating it, but I believe that was something that was being investigated.
So, we looked at, and I'm just going to show you Defense A1. And what's this a picture of?
These were some of the rounds that were located loose on top of the cart.
And these live rounds being loose on top of the cart, I mean, you don't know whether those live rounds were there at the time of the incident, right?
Correct.
And again, these were all Starline brass, nickel primer, live, correct?
Yes.
And you were also not certain at times when you would collect rounds, whether or not they were live or dummies.
Correct.
Some rounds you submitted to the FBI to process to figure that out.
Yes.
And if we could look at State's Exhibit 27, can you tell me what that is?
This is a photograph of the silver primers on the 2 rounds that were later discovered to be live that were on top of the cart.
And so in this box you then collect, which is defense A2. Right. What was your understanding of this box?
My understanding was this was the box handed to Lieutenant Benavidez that was being pulled from at the time to load the firearm. I was then placed in his unit and later collected by myself.
And when you looked inside of that box, State's Exhibit 17, what did you find?
These were the rounds inside of the box.
And can you tell the jury the significance of that round?
Yes, this round with the silver primer was a live round.
But you don't know whether somebody was rifling through this box and just missed one, do you?
No.
And you also showed the jury that these Starline brass nickel live rounds were found in other places on the set, right? This is State's Exhibit 16.
Yes.
And what is this?
This is a close-up of one of the gun holsters that has a live round in it.
This silver one is a
And
live round, they
State's
said
Exhibit
yesterday.
15.
This is a close-up of the gun holster that was belonging to Mr. Baldwin that has a live round in it.
And was then 15 this is 15. Was 16 the one that was the other actor, Jason Eccles?
Yes.
Okay. And so Mr. Eccles, another actor on the set, turns out that he, as he acted, as he performed, had a live bullet in his bandolier, correct?
Yes.
And you have no reason to think Mr. Eccles had any idea that was there, right?
Correct.
Best point so far.
Your working theory, as you evaluated the ammunition and looked at the similarity between the Starline nickel live and the Starline nickel dummies, is that they could have been easily commingled. There?
Yes.
In other words, somebody could have mistaken one for the other, right?
Yes.
And so when you conduct then a search warrant on the church, you find additional evidence, right?
Yes.
And you talked about search warrants in your direct examination, but I just want to orient the jury a little bit to what that is. A search warrant is where you go to a court and you swear out a warrant, and the warrant tells you what you can search for inside of a dwelling or a location, right?
Yes.
And you tell the court what information you have and what you'd like to look for. Fair enough?
Yes.
And unlike somebody sort of, walking into the precinct and voluntarily giving you evidence, one of the things about a search warrant is you don't have to tell the person you're coming before you go, right?
Yes.
So as you're going into execute the search warrant on the church, and the warrants in this case, you did discuss that with Corporal Hancock, correct?
Yes, I believe we had some brief conversations about the search warrants.
And the warrant for the church, it didn't indicate that there was any specific crime you were looking for. Is that fair?
I don't recall.
And so when you went inside of the church, you were looking for evidence, right?
Yes.
And you remember, as you ended your direct examination yesterday, Ms. Morrissey, the prosecutor, said, you keep all of this evidence so that if anyone wants to bring any evidence, you have it, right?
Yes.
Okay. And one of the things you found in the church was the shot list for the day, right?
I don't recall that.
Do you recall collecting paperwork inside the church?
Yes.
Okay. And
Your Honor, I've already indicated to Mr. Spiro that I object to some of these, so we can approach now. I wish we had dealt with it previously.
You and me both. I wish a lot of these issues had been dealt in prelims. That's what they're for.
No,
Yeah.
I think I could just lay it and introduce it.
Well, she said she objected.
She clearly doesn't think you're laying the foundation correctly.
Yeah. Foundation is an interesting issue because different judges are stricter about it than others. Some judges don't really care. Foundation is, why do you know the thing you know?
Mhm.
And how much background? It's like, okay. So if I ask you, did you see the car wreck? I could say foundation. Well, how did you have the ability to see it? Oh, because I happened to be there at the scene, which might be the right answer versus I was monitoring a camera versus whatever. So why do you know the thing you know?
How do you know Biden has dementia? So everyone might say that they know he has dementia, but how do you know that? Is it because you saw him in a debate? Is it because you're his doctor? Is it because he told you? That's establishing the why. There's a lot of facts that we all believe we know. And now when the witness is answering a question, it's important for the jury to understand where they're coming from, and also for the court to understand whether they have sufficient foundation, that they are in a position that they have capacity to actually relay that their information to the jury, or whether there's more speculation involved and that they don't really have the knowledge that they're presenting to the court.
The problem they're raising in this case is they're trying to get at what she learned from other people doing their parts of the investigation. So it's not stuff she has personal knowledge on. This is the whole problem with why she couldn't testify to the FBI's conclusions in the first place. She would be relying on hearsay. She only knows it because she was told that by the FBI, and that's not going to be an adequate foundation for her to testify to any of this stuff. So sometimes it's just as simple as, okay, she can identify this document as something that she seized from the church, and it's true and correct, and it's accurate, and that's going to be enough to get it in as a document that you found in the church. But you may need another witness to be able to explain what this document is. I understand the significance of this document from my own personal knowledge, so I can explain why it is relevant in this particular case. There are some fine distinctions with what a foundation is, depending on what it is you're offering, the purpose you're offering it for. And they seem to be struggling a little bit over some of that.
And there's some things in law which feel ticky-tacky, rightness, mootness, things of that nature. They all standing can feel very ticky-tacky. That's a way of courts jumping around things. Foundation is certainly not that. Foundation is what gives reliability to evidence, that we know it's something that should be presented to the trier of fact, rather than something that this person should not be testifying about. So it's an essential element to establishing good law.
The only way the foundation becomes ticky-tacky for me is, how deep do we have to go to establish the foundation? For example, I observed the car accident. Okay, what's your foundation? I was at the scene. Okay, foundation. How'd you get there, right? So there is sort of a turtles build on turtles thing. It's like at some point we have to say, okay, this is where we're ending the pyramid, and it's foundation enough. So,
well, and then that comes down to who your opposing counsel is, right? Are they the dick who's like gonna get you on a gotcha? Well, you said it happened exactly on this date, and it's not even relevant what date it occurred, right? On a minor ancillary issue. And they're like, well, you said it occurred on this date, but it actually happened this date. And everybody in chat, you have a family member like this, where they're like, well, give me an example. So you say, well, last week you said this, and they go, last week? We didn't even meet last week. It really just depends on who your opponent.
It also matters a lot on the judge, because some judges, it's a stylistic thing. Some judges don't care as much about foundation. Some judges don't care as much about leading, or they'll give more flexibility. Yep. Scope is another one for cross-examination. In terms of scope, what kind of questions can you ask? Are you limited to direct scope? Do they allow kind of unlimited scope? So there's a little bit of flair for each judge and sort of what they like and what they don't like. And that's why you have to know your judge a little bit.
I tend to prefer judges who allow leading on direct for those ancillary points, just to lay the foundation, to say, this is where I was. Okay, and then what did you do? I did this. Okay, then did you see anything? Yes, I saw this, right? Instead of because if you don't have a judge who allows that sort of leading, then what can sometimes happen is you end up in a situation where you're like, what if anything, right? Because you know that it's always going to draw an objection or the judge is going to agree with it. It's a nightmare.
Danny, you have hit on my biggest pet peeve that I think I have since I've started watching trials, which is the judges over stating what a leading question is. Your question was not leading. Did you see anything is not a leading question?
No, it's not.
That's not inviting. It doesn't have the answer built into the question itself. That's what the leading is. If the question was, and isn't it true that you saw X? Well, then yes, that's leading because it's telling the witness what the answer is. But did you see something that's open-ended? But I'm agreeing with you 100% that there are judges out there who will look at that question and they're so overprotective of the direct examination that they're not allowing you to ask things like that are open-ended, but are allowing you to guide the witness to the particular area that you want them to talk about. And that can be so frustrating as a practitioner because you can't get the witness to somewhere without directing them to where it is that you want them to talk about. But you can do that without giving them the answer.
In that context, I agree with you. When you're trying to transition into a topic, I totally agree with you. But I would say that it's that yes or no questions in the middle of something that you're already on topic is I would agree that is leading, meaning
I disagree.
I disagree.
No, I disagree.
100%. I'm gonna fight on.
Hold on.
Yeah.
No, it may be leading, but it's a matter of whether or not it's permissible leading, right? Because
if you can
on
freely
direct,
answer,
some leading is permissible, and
Please
it's
don't
up
talk
to
among
the
yourselves
judge.
or anyone else about the evidence received here in court.
Okay, we're going, I think, to chambers or something.
What happened?
Oh,
Full
shit.
fat. We're going for a full fat discussion on this objection. That'll be
oh
fun.
my goodness.
Oh no!
Yeah.
But I was
But
going to say, if
but
you
it's
have
it's
an
the difference
older person-
between did you go to the park and you went to the park, didn't you?
Well,
Because one is suggesting the answer and one doesn't. One
Just
did you go to the
because,
park
just
is
because you
yes, I
can
did, no,
draw
I didn't.
examples, just because you could draw examples of something that is definitely leading, that doesn't mean that the other one, which is less by the nose pulling them.
Did you see
But Joe, if
it's
you
not
are
also
free
leading.
to answer yes or no, you are given a binary choice. You are not told which one is correct. That is not leading.
So
I
here's
agree.
another example, Joe, especially with, and I'm sure you've experienced this, Joe, when you have a witness who's older and who has a hard time remembering certain things, or not necessarily certain things, but the sequence of events leading up to a memorable moment, they might have a hard time describing, they may have a hard time remembering exactly. And it really helps to say, so did you see anything? Also, a lot of people get very nervous on the stand. And when you're on direct and they're already clammed up like this and they don't want to say anything to implicate anything wrong, they don't want to get in trouble, right? It really helps to have their attorney or another attorney sort of walk them through a testimony. Most people do not testify. Most people have question and answer conversations all of the time. It is very odd to pontificate for the vast majority of people, myself excluded, right? So hey.
Okay.
What's Ron doing? Is Ron throwing
Ron,
shade
you're
here for
back
some
on this
reason?
one, Joe.
Ron, you're not in our
I
group.
agree. I agree that there's that it's a permissive leading. So it's like someone is telling a story over, and ultimately the main event that is the heart of what they're testimony about is some incident they saw in a store. So you say, what did you do that morning? And they start going off into the weeds about how they had a conversation with someone or they were sending emails. And then to have, it's permissively leading to say, did you ultimately get to the store at some point? That's a yes or no question, which is a transition. That transition is exactly what that's what permissive leading is, as opposed to did you see him shoot that guy? And then that's a yes or no question that he can go either way. But that's clearly that's a leading question, which is impermissible in my opinion.
No, see, Joe, I disagree. It's the problem with that question is not that it's leading. The problem is that it is assuming facts that are not in
There you go.
evidence. If we
There you go.
already have it out here that the guy's been shot, then there's nothing wrong with that question. But if this is the first time the jury is hearing that the guy has been shot, the problem with your question is a form one. It's not that it's leading, it's that it's assuming something that hasn't already been established. So these are fine technical distinctions. I agree with you in that context. That question is going to be a problem, but not because it's leading. It's not leading.
Yeah,
well,
I
and
agree with
that's
Andrea.
where I make the distinction between relevant issues or fact or narrative that is in dispute versus irrelevant or otherwise stipulated to or facts that are already in evidence type issues, where as you get closer to the issues, right, the main issues, the main event, at that point, if you're continuing to lead, there's a problem. At that point, if you have to coach them through their testimony of the main event, that's where you're leading. But if it's all of the ancillary stuff, who are you? Where are you from? Okay, and on the night in question, did you see so-and-so? Great. When did you leave the bar? Right? So you're following along with their narrative. It's very smooth. It's a nice transition. Also, you guys, we do have an update in this case, a quick news update. Apparently, the DUI guy is saying that Hannah Gutierrez-Reed is set to testify on the second week.
I'll believe it when I see it. Is all I have to say
According
about
to
that.
court documents.
And Jeanette is reporting this as
I'll
well.
pull it up.
I saw on Twitter that she's saying Hannah Gutierrez-Reed expected to testify tomorrow morning. So they're reporting on an order to transport her, which has been filed in the court. I have seen that. I don't think that that's new information. Anjanette saying in a pretrial hearing last month, the state requested immunity for Hannah. Judge denied the request because the judge Hannah has indicated she would not cooperate. However, since that time, Jason Bowles has filed to have Hannah Gutierrez-Reed released pending appeal. I don't know how that changes anything.
Yeah,
I mean, with respect to whether she's still in jeopardy or not. So I don't know if she's going to testify. I think the issue is they're going to bring her over and then they're going to have to sort out what's going to happen. Is she going to invoke? If she does invoke, is it a valid invocation? Is it something that she can be given use immunity for? I think these things are all kind of up in the air to be sorted out still.
Yeah, see, this is my problem. Like, what has changed fundamentally here? She said she didn't want to testify, as Andrea points out a month ago, which the judge ruled was too late in time to try to do it. The state wanted to offer use and derivative use immunity, which would be sufficient for the Fifth Amendment. So we can force you to testify because we won't hold anything you say against you in a future proceeding. But the judge said, no, I'm not going to give use and derivative use immunity because basically you're too late here. So it's like, okay, so what has changed in time? Why would she testify? Because without immunity, anything she says can be used against her.
See,
that relates to her appeal, which is still ongoing.
But my guess
Any
is
future trial.
This
So I don't get it.
This order to transport wouldn't be in place. It wouldn't have been filed. It wouldn't have been signed by the judge unless something has changed.
Yeah, but what is that thing? And I'm confused.
Probably ice cream. I'm serious. You guys are underestimating.
I want to ask you a question, Kurt, about this because this came up a lot in the Young Thug case. The whole thing with the immunity issue. And the question I have is, how does a state giving you immunity insulate you from potential federal penalties?
It doesn't.
So then how is that something that now we could say, well, your Fifth Amendment rights are waived because you're now not protected. You're now protected. You're not protected. So why should they be allowed? Let me just finish my question. I'd love to hear your answer. My question is, the theory that everyone's talking about here for the last couple minutes is once we give you immunity, you're now not self-incriminating because you can't be punished for it. And my question is essentially, well, even if the state's giving you immunity, since you still might face criminal penalty as a result of the federal government coming after you, so you would be incriminating yourself with respect to the federal government, and they should not have the right to compel you because that's compelling you to expose yourself to federal criminal charges. So that's my question: is how does that work?
Yeah, the relevant law here says that there has to be a true and real apprehension of criminal liability. So the question would be, what is your potential exposure to a federal charged, because the federal government can't typically charge unless there's some sort of federal nexus, which is atypical. So, for example, this case, what potential federal liability could you possibly have? This is an in-state action that occurred on state property. She's not a federal actor. There's no federal component in play. So what jurisdiction does the feds have? The answer would be zero. So without exposure, there's no problem.
And that's different from Young Thug.
Yeah, it's different from Young Thug.
Because Young Thug has federal RICO potential charges coming against him. And that's why I was like, I don't see how there's a real immunity here.
So I can tell you, Joe, I have dealt with this because I've dealt with it in situations where there's gang implications and also in situations where there's firearm implications. Both of those are going to be red flags that potentially opportunities for federal interest to be lurking in the background. So I don't know specifically what could be on the hook as far as a federal prosecution. It's just going to depend on what the evidence and information is. But I can say, as a defense attorney, if I'm looking at a firearm related situation, yeah, I'm going to be thinking down the road of potential federal liability. The way around that, though, I mean, it's the burden is, whether right or wrong, probably always going to end up on the defendant to establish what is the potential exposure, right? What is the crime that you think you're potentially going to be subject to? Because the prosecution is going to do what Kurt's saying. There's no federal hook here. There's no basis for them to get involved. This is an entirely intrastate simple criminal, homicide.
I agree, and I agree. There's no federal exposure here.
So you're going to have to come up with something that would establish here's something that they could potentially be looking at. If the prosecutor is that gung-ho about getting this in and wants to overcome that, it's very simple. You go to the AUSA for your district and you get them to sign off on immunity as well. Because if there really isn't any particular hook here that they're interested in, that won't be a problem. And it's not uncommon for them to do that.
I will say this. If I'm a criminal defense attorney and my client doesn't want to testify and they're getting that exemption, even though I'm not a criminal defense attorney, but I'll tell you this, I would point to the Ghislaine Maxwell trial. She was convicted of interstate commerce, of interstate commerce for all those disgusting things that were happening exclusively in the state of Florida. And the theory that Judge Allison Nathan presented in jury charges was, if you find that they used any product that was brought across state line in the commission of these crimes, that now makes it a federal crime. Anything that think about, do you own anything that has never crossed state lines, that was produced in state and was not? I mean, so if there's a massage bed, in this case they were talking about, if the massage bed came interstate, boom, federal crime. So you're going to tell me that this prop gun wasn't interstate? You're going to tell me that these bullets didn't come interstate? So you want to tell me that oh, sure, she's safe from federal charges because, when she's granted immunity by the state. I'll tell you right now, federal government has a very, very long arm, and they're not slow to use it. They're very happy to use it when the mood strikes them. And that's why if I was her counsel, I'd be like, no, go get me the immunity from the federal government, and then we can start talking. Because they can drum up whatever they want to try and create.
The interstate commerce hook does have a lot of power to it, because even your run-of-the-mill convenience store robbery would technically qualify federally as what we call a Hobbs Act robbery, because, well, don't you know that convenience store is operating interstate commerce? So your point is valid, but I don't know if it's quite as broad as you suggest. But typically, and I don't know if this is true for the Maxwell case, but you'd be looking at a violation of the Mann Act for the transportation of minors across state lines. That would be
right. But they were talking with respect. They were talking with respect to a minor who never left Florida. So with respect to abuses against her, she never left Florida. All the transactions happened in Florida. She was a 13-year-old who was decimated by Epstein and Ghislaine, and yeah, that was the theory. That's how she got convicted on that.
Yeah, I don't know what the federal hook would be in that example. If the minor never left state lines and all the actions occurred within state, I'm not sure what the federal hook would be there.
The other potential federal hook.
It's a conspiracy hook. It's because it's part of a broader, the broader
conspiracy
transaction
across state lines. Okay, fair enough.
Yes.
Yeah.
I buy that.
I've worked on conspiracy cases. Yes.
That works.
Yeah, and the lotion you got from Amazon can get you. Well, wait. Hopefully, you're not doing anything like that, Matt. But the point is, yes, any one of these things. One of the things they try bringing up is that tickets to a show were mailed across state lines. So that's why you got these tickets that were in your local domain. But since they were mailed from a different jurisdiction, that's why now it's interstate commerce and the federal government come after you. My point is the federal government can be very creative in how they can read statutes as a basis to give them jurisdiction. And that creativity would terrify me to say, oh, we're totally immune here. The state gave us immunity. We're totally fine here. I would never want to, as long
as we want to terrify people about the federal reach, the federal government can also potentially reach you outside of the United States borders because of extraterritoriality. If you're a U.S. citizen and you're doing things in another country, it might be a violation of U.S. law. For example,
unless you're in Greece and they have a non-extradition. Well, I mean, you could still break the law. You're right. But they have a non-extradition agreement with the U.S. So, you could just become a Greek citizen and you're good to go. Or at least just get a visa to Greece and hang out there. Get a little green card.
Hang out in Hong Kong. There's no extradition there.
There's a certain actor who did that recently.
Part of what Kurt's getting at here, you're getting at the 10 felonies a day problem, right? The Kurt Silverglade pointing out that there are not only so many federal laws that nobody knows how many there even are. You cannot know. It is impossible to know the full scope of your potential criminal exposure, and because a lot of that is originating under federal administrative law, under all of these.
Although maybe less so with the death of Chevron, and thank God.
Maybe we'll, but it's going to come case by case. And so I think that really speaks to the point that Joe is making here, that if you can't even know what all of the potential federal crimes are, if you don't have a federal prosecutor signing off saying, I'm not going to prosecute for any of this, how can you possibly say there's no legal exposure? We can't even evaluate that as a practical matter.
Yeah.
I know the federal government, I've known U.S. attorneys who play the game. What could I charge the person with? Like pick any random person in the world and just play the game. What could I charge them with if I really put on my thinking hat? They do it for fun.
I'll show you the crime.
Mm-hmm.
Exactly. Right. It's like, and then like the more obscure the law, the better, because that's just play the game better. It's like, what can I, it's like, oh, they picked up an eagle feather somewhere. No, that's an endangered species. I could charge them with that. Or they manufactured something pretending it was from an Indian tribe, but it's not really from an Indian tribe. I could charge them with that.
They digged on their own land that's more than 500 yards away from a dry creek bed that is more than 2 miles from the nearest body of water.
The waters of the United States. That's right. The waters of the United States include your dry land that's not near a waterway.
And we are going to charge you for every single day that you don't put that dirt back. And by the way, we'll also charge you for putting the dirt back because you are still violating the water. So you're going to get charged on top of the charge. I am so glad with the death of Chevron deference that we actually have an opportunity for, especially, what I do like about it is it really brought attention to the issues and it put the onus back on Congress to start crafting better legislation.
I just wanted to just reference this because this was a $20 rant, which we were saying Joe is the master when we were talking about leading before. And I think this is a fair point. I am the master of leading. And I should point out, I'm at 99,493, just 7 away from 99.5. So, and that
everyone should go subscribe to Joe. I mean, seriously, the man deserves it. He's so close to 100,000. We need 500 of you to go up there and hit the subscribe button. Get the man 100,000. He deserves it.
I'll send you my 500 if you send me 500 of yours. Because I'm only at, listen, you guys, I'm only at 11,500.
I'm not the leader of the following. Just want to be clear of that. I mean, my people who join my channel become followers, and I am not the leader of the following. But she's an actual cult leader, so
there's your link. Go subscribe to Joe today.
Thank you so much.
@GoodLogic. Make sure to subscribe and get to the 100,000. The man deserves a YouTube plaque.
There you go.
What's your comment, Andrea?
Recognize, YouTube. Recognize. Laser Doctor says, when I was 10, my cousin shot me with an unloaded BB gun. Safety is in the hands of the holder. I bet Alec wouldn't have pointed the gun at his balls and pulled the trigger, safety was on his mind. We talked about that without the balls example, more with a mouth example. But I think your point is well taken, as it would be if he had pointed it at his own balls. It would have been very well taken. That would have been justice right there.
This is one of the most persuasive points that I think has been made to me, you know, in my mind, about the reckless mental state component. If you would not disregard this risk as to your own safety, you have no right to externalize that onto the other people on your set.
Yeah, and it sort of changes the entire analysis. It changes the entire thing, because there should be no distinction between whether, if it's reckless with respect to yourself, it's reckless with respect to another individual. So the pointing the gun at her is really the worst part of the offense. And if you're not a regular gun user, you might not appreciate that, but it's something that is drilled into you when you're taking basic gun safety. Is you never ever point a gun, loaded or unloaded, at anybody ever. And it's just rule one. And he's been dealing with guns for what, 3 decades, 4 decades? I mean, in the movie Malice that I remember seeing in the 90s, he was handling a weapon at a certain point. He's been dealing with guns forever. Don't give me what SAG tells you, or whatever nonsense was being spewed in opening statements. SAG does not approve, and I think you looked at SAG rules, right? They don't approve pointing a gun at someone. Well, because it's a movie, we have to create reality, so we have to point guns at people.
The SAG guidelines are the same rules that you would get walking into any gun range in the country. It's the same. You're primarily responsible for the safety of everybody. You don't point it at anybody. You keep your finger off the trigger. You don't shoot any, you don't point at anything you don't intend to shoot. These are just the basic safety rules, because of the fact that it is foreseeable that something can happen that can result in a bullet being chambered that you're not expecting. And so you have to take these other precautions because of the magnitude of the harm that would result if you are mistaken.
I will tell you this. I am hoping that she testifies, because that's going to be good theater.
Oh, it'll be outstanding theater. It'll be fantastic theater. This is the ultimate woman scorn tale, because she's been convicted and sentenced to 18 months. She might have some animosity, I would think.
Was she in the room? Because I don't
think she was. Actually.
She wasn't in the room when the gun. Yeah, but there's gonna be. I mean, I would be very curious. Like, she should know more than anyone how live rounds got on the set, right? I mean, you would think she would know. That's the question that the defense wants the jury to focus on. That's more of a court of public opinion or public curiosity as to like what the hell happened. I can sit here speculating as to how live bullets ended up on the set there, but and come up with all sorts of ideas that someone pranking someone, and like all of a sudden a gun actually goes off, and not thinking that people are going to actually be stupid enough to point a gun at someone else. Or it could be people making a statement that, hey, we're not being paid enough here, so like we're not able to be as careful as we are. But I'm really curious, like, when's the first time you identified live bullets on the set? What steps did she take to try and remedy it? And did you talk to Alec about it? Did he know about the situation? And let her come in there. And if you're the state, you're hoping that she told him personally about the incident, which would make, and the reason that would be relevant in this particular circumstances, because that would display greater irresponsibility on his part in not double checking. So, and the irresponsibility is everything here. So as far as
here's a thought I have, because as soon as you were saying that, Joe, I was thinking to myself, there's absolutely no way that the great star Alec Baldwin is going to allow some peon on set like the armorer to approach him and speak to him directly. I just have this very Jennifer Lopez kind of vibe from him that, don't look at me, don't make eye contact, kind of diva attitude. I don't know if this is true. It's just, like I'm saying,
it's the vibe.
my sort of
it's the narcissist
impression
vibe.
of him. Yeah, it's the vibe that I get from him. So I'm wondering what you think of the possibility of a willful blindness type of argument. Like, okay, maybe nobody did come and tell him personally. Is there an argument to be made that he would be responsible for, number one, just paying attention to what is out in the open in front of him, you know, this whole issue with the cart and there's just the chaos and the fact that the guidelines are clearly not being followed as far as the safety meetings, the protective measures, all of that type of thing. Would he have a duty to inquire? Would that be part of his mental state and the standard that we'd be considered? If this stuff is all out here in the open,
what's the foundation of
should
his
you
duty?
ask?
What part of his role creates that duty?
I would start with the SAG guidelines that he's on notice of, and I would point to, again, just what he actually participated in, the lack of the safety meeting preceding this blocking of the scene. The guidelines are very clear that if there's going to be a firearm involved, you have a safety meeting to address that scene and how it's going to be set up to ensure that everybody is safe. The fact that he is being directed to point the gun at somebody, the fact that he's being offered the opportunity to check the gun, just all of these types of factors that could have potentially put him on notice that something is slightly off here. Does he have a duty to inquire?
I like how we've immediately gone from a huge break and now everyone's just back at the bench. Apparently our huge break did not resolve the issue. We still need to be at the bench.
It's funny when you were saying that, Andrea, that like I was thinking about how you can have a really fascinating, philosophically, logically sound argument that could help him legally, which is a certain loser that will make the jury hate him and want to throw him in prison forever, which is, imagine his defense counsel getting up. And this is obviously a loser, but logically sound and saying, look, this is Alec Baldwin. He's a douchebag. He doesn't listen to other people. He's a narcissist, self-involved douchebag.
Yes.
And that's why when an armorer came up to him and said, hey, they're shooting off guns everywhere, that he's not even listening to her. So he's not actually on notice. He's not, because he's Alec Baldwin. He's Alec Baldwin. And logically, it's, you know what? That's the nature of who he is. So he really wasn't on notice, but you just make everyone say, wow, throw this a-hole in jail forever. Even though that technically it's a logically sound argument that does make sense that he's Alec. He's really not on notice. It's kind of funny.
Yeah, I mean, you're thinking along the same kind of lines I was, exactly. That, well, of course I didn't know. Nobody told me because I'm this terrible person on set. And so it does make me think, even if legally maybe there's not a should have known standard that they can rely on, if the jury would perhaps, think that through for themselves. Even if he didn't actually know, he shouldn't have been such a douche on set, and then he would have.
Young lawyers, young litigators, I caution you, tread very carefully before you ever engage in the douchebag defense.
Yeah, my client's an asshole, but being an asshole doesn't make him a criminal. That is always a challenge.
No, I'm saying it's because he's an asshole that he's not legally a criminal. Yes.
Yeah. Yeah, that's one to work through very carefully. Focus group that one as best you can ahead of time.
Well, there's a guy looking kind of smug. Could look a little bit more humble, maybe.
I told you he's never played a good guy, okay? He doesn't know how to act nice. He doesn't know how to do the warm smile. He doesn't know how to be approachable. This is his go-to face. That's his go-to face in every movie, every film I've ever seen him. That's Alec Baldwin. It's very attractive to a a lot of women, actually.
No, it just reads that he's too good to be here.
You can fix him.
Not in a million. You couldn't pay me enough. You couldn't pay me enough to have any sort of involvement with that guy.
He really is reinforcing this impression of he is better than everybody. He considers it an injustice that he's even here at all, having to do that. Imagine that all of us are able to sit here and watch him on camera and he's not even getting paid. I bet he is furious.
You know what?
They're milking me.
Though, to be fair, from his perspective, okay, he is innocent. He shouldn't be there. In his mind, he did not kill her. It's not his fault. Yeah. In his mind, this was a tragic accident.
He should be looking at this as an opportunity to demonstrate some of those acting skills, and he can use it as part of his sizzle reel in the future to show that he's capable of showing empathy, compassion, maybe just a hint of being afraid, a hint of being scared, a little bit of humbleness.
I think
all those things. It'd be good for his career, man.
I think he actually did play a good guy role in Beetlejuice. In Beetlejuice, he was like a good guy. He was like the nice, innocent, husband kind of. But it's been 30 years since he's had to be a good person. So.
That movie came out before I was born, and when I watched it as a kid, I was so like traumatized. Everybody was a bad guy in that movie. I was like, everybody's an a-hole. I don't want to grow up. Life sucks. And I should rewatch it. Oh, he's the husband?
Yeah,
how
I think
did he
so.
get so hot? Wait a second. Is he one of those weirdos that, like, as they get older, they genuinely just get better looking, objectively so? I feel like that's his case. His face kind of, filled in. Oh, wait a second. No, he was hot as he was young.
He was
just his role.
Yeah. Hunt for Red October, I'm not sure is necessarily the best example because he was a smug, arrogant son of.
Sorry, I shouldn't be talking about.
Yeah, he played Jack Ryan in Hunt for Red October.
Yeah, it's great movie. One of my favorite movies of all time. But
I do like Hunt for Red October. That's true.
Yeah, and I'll tell you, in the movie Clueless, like they referred to a good-looking guy as a Baldwin. So he was always that was like that was what they called a good-looking guy was is he a Baldwin?
For me, it was Fun with Dick and Jane. He's such a lovable asshole in that movie. Like, you can't help but think, God, that guy's a dick, but also kind of hot. Like, I loved that movie so much. Have you guys seen it?
No.
Underrated. Underwatched, underrated movie. Fun with Dick and Jane. Basically, it's about the 2008 market crash.
I like the signs on the side of the pews. Attorney, public.
Oh, yeah.
That's a nice touch.
They have that in the Koberger courtroom too. They have the little papers up to make sure you know where you can sit.
They have that in Paltrow too. In Paltrow too, they also bring in people like individually. So they're like, oh, okay, your family, you can come in. Oh, you're the assistant, you can come in. They're doing the same thing with the case that I've been covering of the mother who wrote a children's book about how to survive grief after she poisoned her husband. Corey Richins, they're doing that for her as well. That is such a crazy case. I'm so excited for that to get going.
And the reason I pulled up that chat where about what he said in an interview that he would never point a gun at someone and pull the trigger. So, you did clearly. I mean, that's why we're here.
That's why we're here.
Yeah, I guess the point that he's trying to make, and he keeps coming to the fact that he never pulled this trigger. And perhaps that's why his attorney, we were asking earlier, why his attorney keeps going into this whole whodunit about the props and all that other stuff, is I think that they want to present the theory to the jury, which I guess could be a viable theory if they can sell it, that he genuinely did not pull the gun, that they pulled the trigger. It was completely defective. And that he didn't do it. He was just holding something that just went off by itself. And that the gun that they tested is the wrong gun. That's not the one that actually shot and killed Halyna Hutchins.
The jury's got to be frustrated by this. It's like, you bring me here. I wasn't particularly thrilled to be here in the first place. You're wasting my time. Stop wasting my time. Stop it. It's like the jury's they're not even here. And this is, we went aside presumably to go to chambers for a half hour or whatever it is. And now we spent the last, 15, 20 minutes arguing at the bench about whatever this is. And it's been nothing but objections this entire time. How is this not resolved in prelims? Uncivil
I'm
is
curious
frustrated.
what it is. I'm really curious. I wonder if it's a open the door type issue.
Yeah,
So
maybe.
they feel that the door was opened and this was something that was discussed in prelims, and now it's an
Yeah,
issue
probably.
of
That's
do
what's
we
happening.
allow it in?
Sounds right. Fair.
But this just doesn't feel professional. That in the middle of the day they just have this long break and no one actually has any clue. Do any of you have any clue what they're even arguing about right now?
No.
No.
No. And apparently neither does the DUI guy. He was like, yeah, prosecutors are gesticulating wildly.
They've just, I mean, how did we get here? We've been talking about, she's disclaiming that, she did any sort of investigation with the gun, which makes sense because yes, the FBI did the investigation. She doesn't know if somebody had access to the box. They had no
foundation
reason.
was an issue, right? That was the big.
There was some foundation issue. It seemed like, but just this very last time we came up to the bench, they were going into the search warrants and the conversations about them, the fact that the warrant didn't indicate a specific crime, and he was trying to get into the fact that they found the shot list for that day during the search at the church. And so at this point is when Ms. Morrissey objects, and now here we are. So I'm just having a very difficult time. The shot list, like what scenes they were going to shoot.
Sure. I wonder if she's arguing that opens the door to him being a producer. Because why else is the shot list relevant? Unless it goes to the fact that he knew and he had some control over what was going to be happening next. Oh, she's smiling. She is. She's very smiley though.
Team Brittany bringing in 5 new uncivilians. Good for you, Team Brittany. There you go. We need more uncivilians in this world.
Yeah, get them on here.
We need more Animaniacs too.
And Mara says, for me, it's really the blame game that gets me. If I accidentally hurt, much less kill someone, no matter how minuscule my involvement was, I'd be a whole wreck blaming myself for the rest of my life. Love the legal insights. Thank you so much. That's true.
Agreed.
There you go.
No, I think that's exactly the point, and that is the major misfire with this defense shotgun strategy, because it sounds like he is just throwing up excuse after excuse after excuse, and he doesn't really care which one you buy as long as you buy one of them. And that just does not, I think, resonate with the experience of most of us who would probably be racked with survivor's guilt if we were even close to something like this happening in our own lives.
It's kind of a variant of the douchebag defense, right? When you're like, it's everyone else's fault but mine. I'm the one standing trial, and that's only because they're coming after me because I'm a shiny object. But it's everyone else's fault but mine. The police, the armorer, whoever brought the live bullets onto it. Everyone's fault, but definitely not me. Definitely not me. The one who pulled the trigger. Yeah, it's kind of a variant on the douchebag defense, but. Man, I missed the 20 uncivilian membership.
Oh, yeah. We do love
our
uncivilians.
Yeah, there you go. And yeah, welcome, young black economist. Whew, it looked like they were about to wrap up, right? I was like, oh, here we go. I was like, I gotta get these chats in now while we can, because Morrissey's heading back with a big smile on her face, and all of a sudden they just let's reconvene.
Let's go back.
God.
This is, we're watching paint dry.
She's like, look at my laptop. Look at the word art I drew on here. It's amazing. Check it out.
Why don't we get out the whiteboard and write on that to illustrate our points right there and everything?
Here's Alec.
We could do some pantomime. We'll do some Pictionary. It'll be great. Charades.
For my bingo, speaking of games, she is wildly throwing her glasses around right now. So go ahead and mark that spot in the bingo square. Again, the wild throwing around of glasses.
You have a bingo?
You have bingo? Can we play?
I'm playing bingo. You guys can only play if you're subscribed to my channel. Don't steal my ideas. Jeez.
No, I like it. That's creative. Good job, Danny. Good job.
You guys, we play when there's high profile cases where we don't have dead kids, obviously, because then that gets it super depressing. But we're appropriate. Bingo is appropriate. Come and play bingo.
Yeah. What else do you have there besides the wild glasses throwing as far as?
Oh, we have great ones. So we have prop gun, Seth Kenny, dummy rounds, real gun, patina, exhibit difficulties,
You
chat
keep saying it's
shenanigans.
patina. Where does patina come in the context of this
It's
case?
because Bowles kept saying patina instead of patine, and apparently it's the decorative, or it's the coating or residue that appears on the outside of a metal over time. So it can be
I've always heard
created
patina.
artificially or intentionally.
Yeah, I've heard
I
patina.
don't remember.
That's
I don't
the way
know
I've
if it's
heard it.
patina or patine. I don't remember. But what I
Yeah.
do know is that they argue about it, and it pisses off the people who actually know. So that's on there. Blanks, witness cries, new evidence, Morrissey shrieks, hammer/armorer, speaking objections, defense slays, prosecutor slays. That's what we have so far. So we'll be changing it periodically as we continue throughout the trial.
Yeah, just remember, if you come into contact with something antique and it appears to be dirty or miscolored or something, don't clean it, because it will incredibly decrease the value of the thing, because the collector wants to see the age of the thing.
I thought it is patina.
Don't clean it up.
Is it patina? Hold on, I'll just.
Yeah, I think it's
We're
patina.
now Googling pronunciation on this. It'll be fun.
I'm almost sure it's patina.
It's patina. It's patina,
Yeah.
not patine.
Yeah.
Right.
Yeah,
It's like not Pantene, you know.
it's
No,
patina.
that's a hair product.
Guys, I have a thought here. I'm digging into this idea that you had, that we're getting into an opening the door to the producer role, and here's what I'm wondering, if this is part of what got them there.
Hi, Viva.
It was his argument and basically trying to draw this equivalence between the other actor on set who had the live bullet in the bandolier, and the argument that he had no reason to believe it was there. He is clearly trying to use that to draw an equivalence with Alec Baldwin. Is that potentially opening the door for them to be able to say, well, actually, Alec Baldwin was in a better position to potentially know that there would have been a live bullet in the bandolier because of his role as a producer and the supervision and all of the other information he would have gotten through that role?
Interesting. Yeah, and we talked at the start of this trial about different ways that the executive producer role can come in. But I do want to, speaking of bringing